major breaking news and proof that when I say you need to learn about other areas of the law to defend our right to keep and bear arms, guess what? The proof is just come out now with this filing by the Department of Justice fighting the so-called non-resident handgun ban that says that you cannot take possession of a handgun in a state in which you are not a resident from an FFL. That's right. This law is being challenged down there in Texas, and the Department of Justice has just responded, arguing that the law is indeed constitutional under our Second Amendment. Is it? We'll break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so this is a big deal, folks, because we're starting to see into the mind of the United States Department of Justice under Pam Bondi on certain issues, some of which touch fingers with the Second Amendment, and some of which have some potential problems, which we'll get to in a few minutes. But to begin with, this story covers the case down there in the United States District Court in Texas called Elite Precision Customs LLC against the ATF. This is a legal challenge brought by the Firearms Policy Coalition, I believe, and maybe some other Second Amendment-related groups, arguing that the federal law, originally part of the Federal Gun Control Act of 1968, that says that you can buy a handgun from anyone in America, but you cannot take possession of that handgun unless you're at an FFL in a state in which you are a resident. So if you're a resident of Montana and you want to buy a gun in Texas, specifically a handgun in Texas, but you're not a resident of Texas, you can pay for that gun in Texas, but the Texas FFL will have to ship that handgun to you to your home state where you're a resident of Montana. In my hypothetical, you cannot take possession of that handgun in the state of Texas if you are simply and only a Montana resident. This violates the Second Amendment, quite obviously. It's been around since the 1960s. 1968, the Gun Control Act of 1968 is when we first saw this notion that you cannot take possession of a firearm from an FFL in a state unless you're a resident of that state. It got amended to remove long guns, I believe, in 1986, but the handgun restriction remains today in 2025. So the question is, what did the Department of Justice have to say today in arguing that this law, this federal law, is constitutional and consistent with the Second Amendment? Well, they said quite a bit. But before we go there, let's talk about what was the argument made by the plaintiffs, or is being made by the plaintiffs in this case, arguing that the law is unconstitutional, and then we'll see what the DOJ has to say in response. Here's the main argument made by the plaintiffs in support of the Second Amendment and why this federal law of what is really a non-resident handgun ban acquisition rule, whether or not it's constitutional or not. Here's what the plaintiffs had to say in favor of our Second Amendment rights. The federal laws at issue in this case make it impossible for a peaceable American who is not prohibited for any reason from possessing firearms to purchase a handgun from a federally licensed firearms dealer unless that dealer is located in the home state. It goes on to point out that the Second Amendment of the United States Constitution protects the right of the people to keep and bear arms, and as the government freely admits, the laws at issue in this case, which bar the transfer of a handgun from a licensed dealer to a law-abiding and peaceable citizen of any of the 49 states where the dealer is not located, unquestionably burdens that fundamental right. The issue for this court to resolve is simply whether the government's ban is historically justifiable or it is not. So what does the federal government have to say in response to those observations? Well, they do a couple things. First of all, they try to argue that the restriction is not a restriction at all, and thus the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed, is not implicated. They basically say that infringement is something that is very burdensome. Very burdensome. That's not right for several reasons. First of all, as we've talked about before, if you look at the exact same dictionary definitions, the same dictionaries that the Supreme Court used in Heller in 2008 in the Supreme Court decision in Heller, you look at those same dictionaries of Samuel Johnson, the English lexicographer, you look at Noah Webster, the American lexicographer, and you look at some of the other lexicographers at the time that the Supreme Court relied on, all at the time of the founding. You look at the definitions at the time of the founding to engage in a linguistic or semantic exercise. You'll see that the word infringe or to infringe simply means to hinder, to hinder. And obviously, if I want to buy a gun, a handgun in Texas, but I'm not a resident of Texas, and I'm not allowed to do so, that is a restriction, a hindrance of my ability to acquire a gun. And obviously, and I think even the DOJ admits this, that to possess a gun, for me to carry a gun, which means for me to keep or to bear guns, including handguns, I have to acquire it first. So if you restrict or hinder my ability to acquire a handgun, which this law does, because it precludes me from being able to actually possess or acquire a handgun from an FFL in a state other than my own, well, guess what? That's a hindrance. So the text of the Second Amendment is implicated. Beyond that, one can even argue, and I haven't gotten into this in great detail, but the reality is one wonders whether or not the word infringe has any meaning at the textual level of the Second Amendment. And what I mean by that is to figure out whether or not there's an infringement on the right to keep and bear arms, you have to do the textual analysis first, true, and then you do the historical analysis second under the Bruin methodology. And the product of the textual analysis combined with the historical analysis, the product of that sort of analysis as the gestalt of it, putting it all together, if you will, that gives us our answer of whether or not the right has been infringed. So there's even an argument that the definition of what to infringe means at the textual level is not even relevant because, again, it's given us the answer or the conclusion at the end of the Bruin methodology to figure out whether or not there's an infringement or not. But set the issue aside, the Department of Justice doesn't get into that level of detail, and we don't need to for the purposes of this video today, but we may do so down the road. So the bottom line is the DOJ argues there's no infringement at the textual level, and thus the burden never shifts to the government to justify the historical tradition of firearms regulation analogous to this particular law. But I don't think at the textual level the government stands much of a chance, so I think the burden will be shifted by the federal district court here to the government to show there's historical regulation. And are there historical regulations or some sort of historical tradition of regulations that are analogous to this? And the answer is absolutely not. The big argument here the DOJ makes is that this is simply a commercial transaction regulation, that this is somehow a regulation on business. And because this is a regulation on the firearms business, it falls within that kind of footnote in the Heller case that refers to we're not really messing with commercial regulations here. But that's not accurate for several reasons. First of all, if you think about the laws that the government is citing here are basically saying that, look, at the time of the founding, there were laws on the books that prevented you from selling arms to the Indians. And therefore, we as the federal government can rely on that precedent at the time of the founding that you can't sell guns to enemies of the state, if you will, or foreign powers. And that allows us to say that an FFL does not have to sell the gun to you if you're not from that state. Now, of course, this is hooey because the only principle to be derived by the historical tradition of saying that Americans at one point were not allowed to sell guns to Indians is saying that Americans are not allowed to sell guns to foreign powers, to the enemy. So if we were litigating the question of whether or not the federal government could ban FFLs from selling guns to, I don't know, Iran or to Russia or to China, well, the historical tradition of preventing Americans from selling guns to Indians and to enemies of the state, i.e. to foreign powers that are competitors of America, that would be a historical tradition that would justify preventing FFLs today from selling guns to Iran, to Russia, and to China. But we're not talking about that here. What we're talking about here is FFLs that want to sell guns and transfer guns specifically to peaceable American citizens. So those laws dealing with the Indians have no applicability to why I can't go to Texas and buy a handgun in Texas and take possession of it in Texas. simply doesn't make any sense. But that's the main argument that the government makes here. The other argument that the government makes here is they try to talk about this footnote in Heller. But remember, the footnote in Heller is just a passing reference to say that, look, we are not getting involved right now in what is an appropriate or inappropriate commercial transaction or commercial regulation. That's for a different conversation. So really, you're just dealing with dicta. So it really doesn't help the government get out from under its burden to satisfy and demonstrate a historical tradition of firearms regulation. They still have to do that. Because remember, I am an American citizen. I'm a consumer. I'm not an FFL. Right? So if I'm trying to get a gun and you're denying me the ability to buy that handgun and take possession of it right then and there at the counter, you're infringing or you're interfering or hindering my right as an American citizen. I'm not in the business of guns. I don't sell guns. I'm not an FFL. I don't make guns. I'm just a consumer dude, right? So that gives rise into the sort of the next argument that the government was trying to get into by saying that this is really just a regulation on commercial transactions. No. The only conceivable argument that you have a commercial transaction, I would say, on behalf of the government, is you could try to say at the time of the founding, there were laws such as proving statutes dealing with and making sure that the barrels are protected and not going to blow up in your hand if you fire them and things like this. But the truth is, what those laws were at the time of the founding, those proving statutes and the like, they were really, if you think about it, consumer fraud or consumer protection statutes. So if you had a law that applied to a gun dealer or a gun maker that said this, you can't tell consumers that you're selling to them a 9mm box of bullets or box of cartridges, right? If it's not a 9mm box of cartridges. In other words, you could say that FFL cannot lie or commit consumer fraud on the consumer, and that would be okay. Because at the time of the founding, you did have kind of consumer protection statutes. Everything from the voidability of certain contracts with minors and vendors to, again, proving statutes that says that this barrel will withstand a round being shot through it. Right? You had some of that, but that was designed to protect the consumer from fraud by the seller of the goods. Here, the purpose of this restriction, and there's no debate about this, because if you look at the historical records of what they were talking about in the Gun Control Act of 1968, in the debates, in the preamble, and related historical laws in the 20th century dealing with this particular modern law, it's crystal clear that the modern law is not interested in protecting consumers such as you and such as me from rapacious or fraudulent gun dealers, gun retailers, whatever. It has nothing to do with consumer protection at all. The modern laws that the DOJ is trying to uphold in this lawsuit are laws specifically undeniably designed to restrict access to guns and advance gun control. Specifically, if you look at the history of these modern day laws, they're all about helping states enforce their respective gun laws. It was about gun control. The reason why that's important is to the extent you can show that at the time of the founding, there are historical regulations on the books with a tradition of trying to protect consumers from fraud. That's why they were enacted in the 18th century. But the why that the laws enacted that are being enforced today and they are being challenged today, the why these things are being fought about today, the why they were enacted today in the 20th century, now the 21st century for enforcement purposes, has nothing to do with consumer protection and everything to do with enforcing gun control laws. The whys of the historical laws and the whys of the modern gun laws don't line up, and the principles of those laws don't line up either, which means that any of those historical laws that the government is using for the 18th century will not uphold the law today. So I think that the Second Amendment movement is going to win this case against the ATF. But this gives rise to a point I want to make really quick, and that's this. Remember how I sometimes explain to you that you have to learn about other areas of the law and other cases involving deep state to protect our Second Amendment rights? And some people make comments like, Mark, why are you teaching me, or why are you doing videos on these other topics? The answer is it all comes together. And here's a perfect example. The government is arguing on page 11 of its brief specifically that if the Second Amendment plaintiffs win this case, the injunctive relief should only benefit the specific people named in the case, meaning the Elite Precision Customs LLC, the two individual gun owners, and I think one gun organization. Okay? Now, what the DOJ is saying here, this is extremely important for you to understand, is this. If you are a member of the Firearms Policy Coalition, but you're not named in this lawsuit, you should not be able to benefit from a win by FPC, because the notion of associational standing is not allowed. And associational standing says that if I'm a member of the NRA or I'm a member of FPC or the Second Amendment Foundation or Gun Owners of America, and they win a case in support of the Second Amendment, because I'm not actually named as a plaintiff, I don't get the benefit of that outcome. Now, this is hooey because Supreme Court precedent is very clear on this, that if an association such as the Firearms Policy Coalition sues on behalf of its members and that association wins the case, then the members of that association benefit from that ruling. In the same way, back in the 50s and the 60s and the 70s, if the NAACP suing on behalf of its African-American members won a civil rights lawsuit against the state of Alabama or whatever, against the sheriff or whatever, the members of the NAACP got the benefit of that ruling because they were members of the organization that sued in their names. This is longstanding Supreme Court precedent, what I just said. This is clearly the law of the land. There is some references, believe it or not, by Justice Clarence Thomas raising questions about whether or not associational standing is constitutional under Article 3 of the Constitution, but that's not the law of the land, and therefore, right now, as I see it, if the Second Amendment plaintiffs were to win this case, the members of the association that sued should ultimately benefit from a victorious judgment in favor of the Second Amendment. But I point this out because when I talk about standing issues or these other issues in other contexts outside of the Second Amendment, they have a tendency to come back on the Second Amendment. And why does the Department of Justice care, in my view, about this notion of associational standing? Because what's going on in other areas of American law today is that there's these lawsuits brought by organizations and associations of government employees and government unions attacking the Trump administration, and they're trying to represent millions of government employees. And that's why I think the Trump administration is trying to say that that is simply not a basis to award millions of people some sort of legal remedy if you're suing on their behalf, because I think the Trump administration is trying to thwart some of these lawfare lawsuits going on across the country, which I cover on this channel. And it's important to understand what's going on there because, again, what's going on those other cases outside of the Second Amendment involving these other associations of mostly left-wing groups attacking Trump, those have the possibility of giving rise to precedents that come back into the Second Amendment context. And this issue that DOJ just raised about associational standing is exactly the point, that it becomes an issue for the administration outside of the context of the Second Amendment. And now today, we have to talk about it potentially as we being collateral damage to that other big fight outside of the Second Amendment, but it has a ripple into our area here involving the right to keep and bear arms. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxing Diner. Don't forget to subscribe both to YouTube and to Rumble. I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.